I must use this opportunity to endorse the Aalto EE Game Executive Program. I think it's a really nice thing that Sanna and the others are doing there. So great work there. But yeah, today's topic, my name is Hannu. I come from Fondia. We're a law firm based in Finland, Sweden, and Estonia. We have roughly 100 employees, some 65 lawyers, and one of our focus areas is startups and gaming companies, gamified companies. And that's why I'm here. Great honor to be speaking. Today's topic, IP and legal, stuff that matters for gaming companies. I'm going to mostly focus on IP and privacy, some key takeaways for developers that they should take into notice in the game development process. I think this was actually first supposed to be a panel discussion, but I was the only one who wanted to talk about legal stuff, so now it's a presentation, but please bear with me. Okay, if we think about the main assets a gaming company has, obviously the first one that comes to mind are the people, probably the most important aspect of a gaming company. But then when we think of the product, the game itself, it's practically 100% based on IP, intellectual property. And when we think about IP rights are mainly rights that give you the right to say no to someone, as well as the right to say yes to someone. So let's think about the game being distributed in an app store and the end user download it. Obviously, they can't distribute it forward for commercial purposes. You might want to take into notice how they can create fan content, distribute that. Can they monetize it or not? Or let's say that you have a user acquisition campaign. You're putting the banners out with your partner. You might want to agree with the partner how they can use those banners, where they can show them, where they cannot. And then if the banners were created by a creative agency for you, you might want to ensure that the creative agency hasn't put in anything fishy into the banners and that you have the right to give it to the partner. So this not very creative agency level type of picture, but it says all your base are belong to us, which is from early 90s game. So ownership is the main key word here. And then when we think about IP, what does that cover? It actually covers a lot of different things. In this presentation, I'm going to focus on copyrights and trademarks. Copyright is probably the king in game development. It's pretty good because copyright is free. It's created instantly when you create the work, and it's global. So a pretty good asset to have. Copyright can be on music, on graphics, on the code base, everything that is visualized or can be heard or seen. Then trademarks, those are for the brand, to protect the brand and differentiate your brand from others. There's there's a lot of different approaches on how aggressively you want to protect your IP or monitor it or enforce it. I'm not going to tell you how to do that, but these are the sort of principles we're talking about. So IP is basically about ownership and the right to say no and yes. So how do I protect my base? There's 3 things I'm going to focus on here, and there's tons of others as well, but these are, in my view, pretty important. Number one, contracts. At least in the indie scene, it's pretty common to do stuff on a handshake. I think it's great, and one of the reasons why the Finnish gaming industry is so good. It's a sharing economy, and I don't want to be a party pooper there, but there are some contracts that you have to do in writing, or I strongly recommend to do that. Another thing is about the game development process, how you should document that. And the third one is about registrations. You might want to register trademarks, and at least you might want to register your domain names and social media accounts and those types of things. So those are maybe the three areas which you should focus on when you think of how to protect the game. I'm going to split these into three areas. You might have stuff that is created for you that you put into the game. Well, obviously, in the beginning, you have a set of founders who are maybe friends together. They have previous experience from working at another firm, who start to develop code base and graphics and music and what have you, and put it into the game. As we think of the copyright rights and that area, the copyright is created by somebody, and that somebody who creates it owns the copyright. That's the sort of main rule. So if we think of these all friends and the company, it's the main goal is that the company should have the IP that's created. So there should be some sort of written document between the founders and the company that says that, hey, the IP belongs to the company. Shareholders agreement. You might also have friends who are employees, they're not founders. There again, you should have a written employment contract with those guys and girls. Number three, maybe the sort of most misinterpreted area is consultants that you might have. You might have someone who's not employed by the company, who's not a shareholder there or founder, who creates, say you ask your friend to create music for your game, and you shake hands and it's all fine. But again, if we think about the IP being with a friend of yours and what the friend might have thought where you could use that asset that they're creating, I would definitely go for a written agreement with those friends and consultants, saying that the IP belongs to the company. Okay, so the stuff created for you. Obviously, in today's world, everything is not created from scratch. I'm not here to claim that. You have a lot of stuff that is readily available and what you might put into the game. And here it's also good to see that the stuff that is readily available might be included in the stuff that your employees and your consultants give to you. Yeah. So the stuff that is readily available, you might have, for example, fonts. Fonts are a good example. You're probably not creating them yourself, you're downloading them from a website, they're readily available. And then there's the license text attached to those fonts, which not that many people read. But then again, that license says how you can use those and how you can't. So I would strongly advise to have a look at those license terms, or a graphics engine, if you use open source, you name it. So, and this stuff could be included actually in the consultant's work. So when you have the agreement with the consultants, you might want to agree with them if they can put open source in there or if they can't, and so forth. Okay, so now you might have the written agreements in place with your founders, your employees, your consultants. you really know what's included in the game and that you're distributing it correctly. You, of course, don't want to step on someone else's toes. You don't want to have a game that's been out for 2 years and then there's someone else coming that, hey, the name you have for this game is actually mine. You have to change the name. Obviously, you don't want to do that. And here we come to trademarks. I mentioned trademarks are brand protection. Trademarks are country specific. So if I have a trademark in Finland, I don't have it in Sweden. And if I have it in the US, I don't have it in the EU. And you have to actually register the trademark to have it in place. I think all of us remember to go to Google Play and Apple's App Store to check whether there's existing games that might have similar names or similar logos to ours. But in addition to this, what I would do would be to check the public trademark databases for existing names, so you don't have a conflict there. There's a lot of databases that are free to use. It's a quick Google search. For example, United States Patent and Trademark Office, USPTO, they have a good website. And for Europe, we have Trademark View, TMView. So go there, check out the name that you planned, and see that there's no underlying trademark available that might not be in distribution. I think there's a lot of IP owned by the big players who are not in the mobile space right now, but some of them have pretty aggressive strategies of defending their rights, even if they're not using the mark. And of course, if you ask me, I would recommend to register a trademark at least in one country. Okay, then the question is that, hey, the market is global. What good is it if I have like a Finnish trademark? I don't have any protection in the US or anywhere else. The good thing about trademarks is that if I first file in one country, I have a 6-month grace period to extend it. So let's say I file something in Finland today. Within 6 months, I could file a trademark in the US and get protection for day one. So if we think of a gaming company, for example, in soft launch phase, if you file trademark then, within 6 months, you might know if the game is good enough to go live with that name and that brand. And then you go live, and then you file for additional trademarks. That's my recommendation. They're not that expensive to get in one country. And at least I would file for the game name. Okay. So that was a trademark, and then we have the copyright. Last but not least, copyright is about the way the game is presented, the way it looks, the way it sounds. Protecting an idea is generally not an option. Let's say that I've created an endless runner. Obviously, I can't go everyone and say that, hey, I own endless runners and nobody else can do them. So that's not an option. Although in some countries you can have software patents, you might have a certain method. Maybe you have a dialogue that opens up in a certain way, and there might be something you do to open that dialogue. It's possible to patent that in some countries. I wouldn't say that this is an important thing to check in the development phase, but especially later on, it might be worth considering. Some companies go for that. And then, of course, there's the patent trolls, especially in the US, who wait for you to be big enough and then they come after you. End user terms. Pretty important document that you might not need to do yourself. If you're in the mobile space and you have a pretty standard game where not that much user-generated content, you might be able to go with the help of Apple and Google and the others, because they have created this sort of standard end-user term set. If you don't have anything yourself, the standard set applies. It's not good for everyone. It depends on the situation, and you can read it online, so you can check if it applies to you. But I don't think that all games need to have their own end-user terms if you're in the mobile space. If you have a browser-based game that is not on some platform, then obviously you do need that. However, a privacy policy should be drafted if your game is internet connected. I'm going to come back to that later. Okay, credits. Copyright, as I told, it's by default it's created by somebody who owns it. So if you agree with them that the ownership transfers to you, you might still need to credit them. Some companies are doing a good job at crediting, some don't have any credits. I recommend to do a set of credits in the game. And of course, domain names and social media accounts, it's much cheaper to get them acquired before you go live big with the game. It's just a matter of Googling a bit. And it's very expensive to buy them afterwards, even though if you are sort of right and it's just a domain squatter who has registered them to sell for you, it's very hard to get them by legal means. Or, I mean, like, by suing someone. You usually just need to buy them. So it's much cheaper to get them in an early stage. Okay, privacy. As I mentioned, if your game is connected to the internet, it has some interaction with servers, I would say that you need to have a privacy policy. So what is a privacy policy about? It's a document for the end users where you tell what data you collect and how you use it. If you give it to someone else, let's say that you have a advertiser SDK integrated and there's data flow right out of the game, it's important to tell the end users that this is the case. I don't think people are doing a good job right now to make a privacy policy. There was a survey from last year by GPEN, which is the Global Privacy Enforcement Network. It's consisted of national privacy authorities. They investigated a set of mobile apps, and they found out that 92% of the mobile apps had some concerns with privacy, and 54% of them didn't have a privacy policy at all. So I don't think it's a very good situation. They actually had a new survey this year, and they are publishing the results in August, September. It's a much bigger. I think right now they had 2,500 companies, mobile developers evaluated. So it's interesting to see if there's progress on that end. And also there's some of, like, when the BlackBerry store require that you must have a privacy policy. You can't post a game if you don't have it. And some analytics companies require, for example, Flurry. If you use Flurry, you need to have a privacy policy. So in addition to the authorities being angry, then the analytics company might be angry if you don't have it there. Right now, if you're a Finnish developer, people think that, hey, if I don't do it, then what happens? Right now in Finland, there are no fines that you could get from the data protection authorities. They haven't been that active in the sector. but as some of you might have heard, there's a new privacy regulation coming in that applies to the EU, and they have pretty hefty fines. You can get millions of euros in fines for not obeying privacy laws. I don't know where it's going to lead, but at least it's something that would be nice to take into notice. So I really think privacy is one of the emerging areas where you need to focus on. Okay, I went through some of the game development process, copyrights, trademarks, make your agreements in writing, document your development process, and then make the privacy policy. It's not a big deal. You have to sit down and consider how are you collecting data and where does it go and what are you using it for. So, any questions?
Do you want a mic?
When you say document your development process, what is exactly the interest in that? What advantages does it grant you in the legal sense?
Thank you. I think the biggest advantage of documenting it is that if something would go wrong, if somebody else would come and say, hey, this is a rip-off of our copyright, then you could have the documents available that, hey, on this date, this guy or this girl created this asset and it's ours. So it's a way of giving proof of what you've done. And there's no sort of law saying how you should do that. So just put it on paper, maybe make a shared folder somewhere and just have a document. I think in some cases, if you don't have any documents, then you would go to sort of photos, metadata, and check out the creation dates, and that's the sort of last. But it's better to have some sort of process available.
Okay, another question here.
Sure.
Hi. Quick question on credits.
Yeah.
You mentioned credits for us. We know credit as the item in the menu where you list everybody who's been involved in the game creation. Did you have something else in mind? And if, I mean, what does it help for?
Yeah, good question about credits. I think at least you should list the people within your company who have taken part in it. There's no sort of, it's a bit vague, the area on who you should list and who you shouldn't. I think if you use external consultants who are sort of acting on a company level, it's not that common. If you use like a creative agency who do some banner art and you attach a character there and the character is done by you, you might not need to credit the one who did the banner behind that. But it depends on the situation. I think if somebody has a big impact on the result of the game, I would credit them. And then there's also, if you're using some standard component like some open source component, they might require that you tell that, hey, this physics engine is from da-da-da address and created by this and that guy. So there's some discretion and then there's some requirements.
Okay, any other questions? I guess not. So thank you very much, Hannu. And
thanks.